matter of the Taylor, Simkova and the Secretary of State for the right of pensions.
Yes, Mr. Dyer.
So, my lord, we got to the case of Dreyer.
Yes,
Which
just
is-
remind me which number that is.
Tab 32, the authorities bundle. It's a case decided very shortly before IP's completion day, 2019. The case concerned contributions paid to a French National Solidarity Fund, the CNSA, which in turn funded the Personal Independence Allowance, the APA, and Disability Compensation, the PCH. And the real issue in the case was the role of means testing. And you can see that, first of all, from the question as referred at page 760, means testing and tapering. So. And then the way, in its characteristic fashion, the CJU recharacterises that question at 28, because it says that the referring court wishes to know, in essence, whether Article 3 of the coordinating regulation must be interpreted as meaning that benefits, such as those two, may, for their purposes, be classified as social security contributions. Within the meaning of that provision, even if they're granted without any individual assessment of the recipient's personal needs, despite the fact that the calculation of their amount depends on the recipient's level of resources or varies according to their resources. So, is it relevant that it's means tested and tapered? And the answer to that is no, that's not relevant. So at 34 to 35, you have a recapitulation of the case law on means testing and an emphasis that the key criterion is the presence or absence of discretion. You have a description of the benefits operation in question at 36. And then of relevance to us in particular is the analysis at 37 and 38. It is therefore clear from the provisions of the Social Assistance Code that the recipient's resources are not taken into account in conferring entitlement, but for the method of calculating those benefits, as the benefits must be granted if the applicant satisfies the condition for eligibility. It follows from
in the case of universal credit, is there not a financial condition which governs eligibility?
There is an ultimate financial condition in the sense that if your income exceeds a certain threshold, you won't be eligible. That's correct.
So is that not a difference between universal credit and the benefit being considered
in our submission
in Dreyer? Because there they say in 36 that eligibility is independent of resources, but here resources is one of the conditions for eligibility in the first place.
But I think
before you get on to any question of calculation,
I think in Dreyer, the point is that the resources are relevant to a cut-off point, as all tapers are. So whether or not you call the taper point where it slips to naught entitlement or not, I don't think really is the substance of the issue. Indeed, if it were, it's difficult to see how the same analysis could have been adopted in Commission in the UK, because child tax credit worked in exactly the same way. And indeed, when you slip below to a certain rate, you arrive under the scheme of an act with an entitlement of 0, because the taper has taken you down to 0. What these cases are really saying is that tapering and means testing don't detract from the fact that the benefit in question is nevertheless a social security benefit. And that's critical to understanding where the Upper Tribunal went wrong, because what's absolutely central in the Upper Tribunal reasoning at 47 to 48 is the focus, to the exclusion of absolutely everything else, on means testing provisions, income provisions, tapering provisions, and the way that the blended entitlements give rise to a common amount applying such means testing and tapering provisions. So those are the cases on classification I wanted to show you. The next topic is the cases of the CJU in relation to severance. And let me be quite candid from the outset. These cases are relatively underpowered. And the reason for that is the leading case, Commission and Parliament, as we'll see, is really no more than a statement of result in relation to severance. The court says agreeing with the Commission that the benefits in question can be severed without explaining why, and that goes to my Lord's question, what is the test for severance? You will look in vain in Commission and Parliament for that actual test being articulated. The court simply says the benefits can be severed.
Well, in fact, the court said the United Kingdom could, if it wished, sever the benefits.
Quite right, my Lord. Adopting the position of the Commission that they were severable, as we'll see. The place that you...
But they're severable in the sense that the United Kingdom could re-legislate, reframe the legislation so that they were separate benefits, with the result that one of them could be included in the table.
And that's why we say, my Lord, the real test for severance is actually in the later case of Bartlett. It's paragraph 21 of
Well,
Bartlett.
that may be, but I mean,
I'm going to take
in your skeleton argument, you majored on the European Parliament case, and I don't think it says any more than if you, the United Kingdom, wish to redesign your benefit system, you can separate out these components, and one of them could be on the list.
I entirely see my Lord's point, but what I'd say in response to it is that Bartlett effectively was a reference in relation to the same legislative setup. Nothing had changed. It was still the old Regulation 1408 setup, the same old entries. The benefits weren't changed. And the court said, in fact, the test is whether or not, hypothetically, it could be a separate benefit, not whether in fact it is. And that's paragraph 21 of Bartlett, as we'll see. So let's come to the cases which... I can see my Lord has already read, as he always does, extremely closely and carefully. Commission and Parliament is at tab 23 of the bundle. The important context to all of this is that under Regulation 1408/71, the gateway then operative to be a special non-contributory benefit was considerably narrower than the gateway under Article 70 that I showed you. And you can see that from page 478 to 479 that lists the relevant provisions from the old Regulation 1408/71. And in a number of respects, this is a much narrower substantive gateway to get through, so a much stricter exception. And the practical consequence was that for most cases, the provision that you had to satisfy was limb B, that they were designed for the protection of the disabled. And that led to no end of arguments about whether or not benefits in question were invalidity benefits, because that's where disability benefits fall in the scheme of risks in Article 3, or care benefits. And you can see the background to the case is that a variety of member states had listed disability benefits in Annex 2A, or attempted to do so. The Commission, when looking at the amendments to Annex 2A, looked at the proposed lists and took out all of the things that it thought, applying the recent case law of the court, the cases of Jauch and Molinar I mentioned earlier, were in fact care benefits, because it said care benefits don't fall within this threshold of special non-contributory benefits. See that at 11 and 12, applying criteria drawn from the case law of the Commission, the Commission excluded from the 41B list the various care benefits as identified from Yao. But then the Parliament and the Council passed legislation containing the original list, the objections of the Commission notwithstanding. And that led the Commission to the unusual position of challenging the legislation as passed. And so the central issue in relation to all of the benefits listed were effectively, are these invalidity benefits or are they care benefits? That's how the topic arose, and you can see the question of severance first arising at paragraph 17, page 483. And this was prompted by the Advocate General's opinion that and this is where you have to be careful with the concept of severance, that the Annex 2A entry in relation to disability living allowance couldn't be severed. In other words, it couldn't be treated as two entries, one for care component and one for mobility component. And if you go back to the Advocate General's opinion, I think it's paragraph 106, she addresses the topic of severance in that connection, directed to the question of the severability of the entries in Annex 2A. She takes it as read that mobility components and care components are separate benefits, and she analyses only the case in relation to care components. And she says care.
Which paragraph of the AG did you say?
I think it's
100 in the next tab, I think.
It is. I think it's 106. Maybe it's a bit later. Thank you.
No, it's not 106.
It's right at the end. Let me just find it my.
One 116 maybe.
116, 118. It's actually 118. And it's that approach that leads the Advocate General to say the whole Annex 2A entry has to go, and because it has to go until such point in time as there has been re-legislation replacing it in a narrower form, both the care component and the mobility component are exportable.
Yeah.
So that's a very different type of topic of severance, but I think it's important to understand the comments that are made at paragraph 17 about why the UK was seeking to reopen the procedure. After the admissibility issues are dealt with, the substantive analysis starts at page 487. And you have the arguments of the parties set out, and effectively, in relation to the UK benefits, you see the position of the Commission at 41 and 42. Such benefits are mainly intended to meet additional expenses which a person may have to bear because of his or her disability, with a view to improving his or her state of health and quality of life, and therefore applying YAUH, they supplementing sickness, and accordingly they have their own characteristics and they must be regarded as sickness benefits. The contrary arguments at 47 to 50. This is relevant, not least because the Parliament is saying somewhat ambitiously that a benefit could be two things at once. It's the only place we can find in the case law where that argument has been attempted, and that argument is shot down by the court. You can only have one characterisation for each benefit. It can't be multiple things at once. And you see that very much at 51 through to 56. 56 repeats the time-worn case law about the twofold test for being a social security benefit. And then at 65 to 69, you get the analysis in relation to the UK benefits. First of all, the court says all three are by their nature, although only partially in the case of DLA, care allowances. 67, contrary to what the UK asserts, only the DLA could be considered to include a social assistance component. The others have a single purpose, which is akin to the Swedish disability allowance, namely to help a person to overcome his or her disability in everyday life. Then you get at 69, the Commission observing that the mobility component of the DLA, which might be regarded as a special non-contributory benefit, is severable, so that component alone could be included in the list in Annex 2A as amended if the UK decided to create an allowance which concerns that component alone. And that seems to be saying the Commission's accepting that because it could hypothetically be a separate allowance, it is severable. And that is, in fact, the test that is then applied in Bartlett. And the court effectively then parks that issue, and it does so at 74 by suspending the temporal effects of the ruling. So it takes the step that the Advocate General...
Can I just go back to the context of 69,
Yes, my lord.
which is 68. I'm just trying to understand what the court is saying, where it says, according those three allowances, as well as the preceding allowances, must be regarded as sickness benefits, even though the DLA includes a distinct part relating to mobility.
That's right.
So is the court saying that it isn't severable, but that legislatively the UK could?
That's what it's saying at that stage. And it's parking the issue because it suspends the temporal effects of the ruling.
If it had severed, it would say, well, you can have your DLA or your mobility allowance on the list, but it didn't say that. It said you must go away and redesign your system,
Well,
if that's what you want.
my lord's quite right, and it's that very opacity of the judgment and the suspension of the temporal effects that actually led to the later reference back in Bartlett, because the parties were saying, none of this has happened. What should we in fact do? How should we in fact treat it? And so I think the accurate reading of Commission and Parliament is it raises the topic of severance. It says, in principle, they're capable of being severed, and it leaves open the question of whether or not they have to in fact be severed in order for the separate analysis to run, and they leave that open by parking the temporal effects.
So this stage, the court isn't saying that it's severable, therefore you have a right. It's saying it's severable, therefore it's up to the legislature of the relevant member state to decide whether it should sever and create a right. I mean, the crucial question is whether it creates the right there and then.
I see my lord's point, absolutely, and I think the honest answer is that that is ducked at that stage by limiting the temporal effects.
Yeah.
Because the UK has lost the argument about all of these benefits being in substance disability benefits, and the court has effectively, in reflection of the fact that there is a distinct component, effectively given the UK through the suspension of temporal effects time to go and sort this situation.
Can we just pause a minute on
Yes.
separate components? I have to confess I haven't read the legislation, but I have read the AG's opinion, and she describes it, para 22, page 506 of our bundle. She says disability allowance consists of two components, a care component and a mobility component. It's agreed that the mobility component is the SNCB. And then she says at 24, the award of benefit is determined solely by reference to the period of time. The three different rates of benefit are granted irrespective of whether the claimant has an income, pursues an employed activity, is unable to work, or is in receipt of other benefits. Claimants are entitled to spend
That's right.
as they wish. And then she says at 26, it can't be determined by reference to the case file whether entitlement to carer's allowance is dependent on the income of the carer. And footnote 13 says that in its intervention, the UK describes carer's allowance as a benefit which is not income related.
That's in relation to a separate benefit, my lord. If you look, the heading C is above paragraph 26, and that's all about carer's allowance rather than disability living allowance. DLA, I recollect, because I think I did quite a few of these cases. Indeed, I think I did Bartlett up until the written observations for the government. DLA was not in any way means tested. It is entirely non-contributory. The two components were the successors to the benefits at issue in Newton, which were previously called incapacity benefit, I think. And there were two distinct components, and they were awarded following effectively a health assessment, not a million miles away from the assessments that now underpin ESA, the limited capacity for work-related activities type assessment. But the two elements had a distinct function, and they were separately awarded. They were applied for by the same form and same process.
So you get one but not the other.
You could get one but not the other. And there were different rates within the benefits depending upon the degrees of disability. So that was the basic structure in question. And of course, just by reference to universal credit, depending upon your factual circumstances, you can get the child element or not get the child element, depending on whether or not you have children. In that sense, it's really no different at all. So, at that point, we had to turn to Bartlett, which is tab 26 of the Bible. Because the genesis of Bartlett is effectively the Upper Tribunal referring a question saying, what do we do in circumstances where nothing's changed and the Annex 2A entries are the same as they ever were? What's the position? Do we have to export both mobility component and care component? Now you get from the holding that the mobility component of DLA was a severable non-contributory benefit, and that it was a separate benefit, and that accordingly the mobility component constituted an SNCB within the meaning of Article 4.2a. And effectively, the questions, which are at page 607, are condensed and answered, and in particular they're condensed and answered at 20 and 21. In order to answer those questions, it's first of all necessary to determine whether the mobility component of DLA can be regarded as a benefit on its own within the meaning of Article 1T, and that's with nothing in the legislative regime having changed. In that regard, it must be borne in mind that the Court held in Commission and Parliament that the mobility component is severable.
But if you go back to 11, it sets out the legislation. It says in terms that it consists of a care component and a mobility
Yes.
component. And a person's entitled to DLA may be an entitlement to either component or both of them.
Yes, yes, but that's the same legislation that was in issue in Commission and Parliament. It's unchanged.
That's common ground.
It's exactly the same legislation. There's been no legislative change in the interim, and effectively, what the court is actually being asked to do is to come off the fence about whether or not they can now be severed without being spun out into separate benefits. That's my point, and that's why this is the missing piece of the jigsaw. And that, you may say with some sleight of hand, is answered by saying that in Commission and in Parliament they say that the component is severable. Why is it severable? Because that component alone could be included in the list in Annex 2A as amended if the UK decided to create an allowance which concerned that component alone. So there you have the test. The test is hypothetical separation. Because it could be spun out into being a separate benefit, it should be treated as being severable. Now that's the test of severance in our submission, is could it stand as a separate discrete benefit, albeit one talking to the other benefits around.
It's a very strange test.
It is, to an English lawyer, with all the connotations.
Could the member state rewrite its social security system so as to create a separate benefit which has these characteristics? Well, of course it could. It can do what it likes.
Well, whatever my lord may say about the test, the first point is that is the test. And the second point is that that test is not hard to apply in this case because of the clearly distinct history of CTC as a distinct benefit, indeed its current continuation as a distinct benefit. So yes, it's a fairly opaque test, and that's why, intellectually, honestly, I hope, I recognise that the case law is undercooked on this subject. The test is quite open-textured, and if it were the case that you could refer, then perhaps the natural thing to do would be to refer to ask for greater expansion or clarification as to how that test operates.
Well, the court must also have thought that the answer was obvious because they didn't have an Advocate General's opinion.
Yes. They thought it was obvious because it had been dealt with before in Commission and Parliament, and they thought that they were being tasked with answering something that they'd already dealt with. The real truth is that the significance of this case was the later passages that effectively found the old Annex 2A entry for DLA as a whole operated to cover the separate component. In other words, if you had an over-expansive entry in Annex 2A, that still saved a benefit that met the substantive test. And that was what was really going on in the case. There we have it. That,
I'm just looking, it says that it was a 6-person court and there was an AG. Was there an AG's opinion? It says,
Well, they say
Appellant
at
Razak, but sometimes they-
page 603B, the court proceeds to judgment without an opinion by the Advocate General.
Yes,
I
that's
think-
right, because they assign an AG
and then it's dispensed with.
then the AG is consulted and they said that's the process, isn't it? So one is assigned.
That's right. It's after the procedural reforms that introduced the ability to dispense with the Advocate General's opinion after the Advocate General was appointed.
Yes.
And it's always with the consent of the AG that you forego it, because the AG says there's nothing interesting here to see.
And Judge Sheeman was on the court.
Yes, I noticed that too.
So there we have it. That is the test.
Can I just looking at paragraph 21, just
Can I just ask you also, just before we get back to that, sorry, I don't intend no discussion. It's all then wrapped up at 30 to 32.
okay.
Because they say it must accordingly be held that the mobility component must be regarded as a special benefit, etc. And they say it cannot be validly claimed that the mobility component cannot be regarded as listed in Annex 2A on the grounds that it does not appear there, but through a reference to disability allowance as a whole. That's enough. So I'm sorry, my lord.
Yeah. So maybe this is reading 21.
Yes.
So they apply the hypothetical test. They concluded it is capable of being addressed separately.
Yes.
But they then go on, if you then ask yourself, what is the legal consequence of that? Does that create a right, or does that then create a power for the United Kingdom to change things? You've still got the conditional if in line 5, if the UK decided to create an allowance.
It must create rights, my lord, because otherwise the critical restrictions that flow from being an SNCB.
Is it the last sentence? Just help me. It follows that the mobility component by itself constitutes a benefit.
That's right. And because it constitutes a benefit, a separate benefit, and because it separately meets the criteria for being an SNCB, as they've already decided, it follows that the consequences of being an SNCB, namely non-exportability and the new special rule on export in Article 10A, operates. And that must be on the plane of creating or altering rights, because what the consequence of that is that the right that you would otherwise have as to the exportability of the benefit is abrogated. So this is all producing direct effects on the planes of rights or no.
So that's the critical thing, isn't it?
It is.
That the extent to which that categorisation either just creates a renvoi back to the member state saying you've got an option, do it or not, or it has an immediate legal effect.
And it does, because it's deciding whether or not the rule of non-export contained in Article 10A of the old Regulation 1408/71 operates to limit the rights that someone would otherwise have to export under the regulation. And remember, of course, all of the case law approaching the topic of SNCBs approaches it on the basis that this is a limitation, an exception to the general rule and right to the exportability of the benefits. That's the right for the individuals in question. This is an exception that operates to qualify that right. So it's producing direct effects in the national legal systems.
That, so 30, it must accordingly be held that the mobility component and the mandatory must be regarded as a special benefit within the meaning of 4.2 as amended.
That's right. And if you go back to the facts of the case,
So it does, okay.
if you go back to the facts of the case, the concrete manifestation of that is, I think Mr. Bartlett, Gonzalez, etc., had moved back to, I can't remember exactly where, I think it was France and Spain, and they were seeking export. And the consequence of this ruling is that they couldn't export the mobility component because the mobility component in question was meeting the two requirements of being an SMB, the substantive ones and the being listed in the Annex 2A. As such, their rights were
Can I
abrogated.
just ask you about paragraph 31?
Of course, my lord.
You say there's been no change in the domestic legislation.
That's right.
That seems to be right. common ground, this Smythe says. But what the United Kingdom seems to have done is that it did cut down what it put in Annex X and included only the mobility component.
Yep.
So although it had not changed its legislation, the United Kingdom government had said, we will sever this and we will put only the mobility component into the list.
That's not quite accurate with respect, my lord.
Right?
What had happened was that the United Kingdom had secured an entry in Annex 10, which I showed you yesterday, in fact, for DLA mobility components.
That's the ones right at the end of Annex 10.
That's right. And that would operate for the cases that were governed by the new Regulation 883. And what the court is saying at 31 is, well, look, the UK has done this for the future in relation to Regulation 883. So they're saying effectively, so we really shouldn't adopt an unduly strict approach for the past in relation to the old wide entry, which is DLA as a whole. We'll treat that as being directed at DLA mobility component.
But it's still the act of the UK government.
No, it's the act of the European Parliament and the Council, with respect, on the initiative.
Right,
Okay,
all
yeah,
right,
yeah.
yes.
It's the community legislature
Yeah,
has changed
all
the list at the instigation of the UK. But the case was entirely argued, and it was entirely confined to rights under Regulation 140871. They're just simply saying the change has been made in the future, and that's a factor we're taking into account. I think that's a fair point. So that...
I'm sorry, just before we leave 31. The first part of it, what is the court saying? So the second applicant had made an argument. The second applicant was...
Mr. Ramos or Gonzalez, one of the parties.
He was one of the litigants, private litigants.
That's
So
right.
as to whether, as he argues, such a benefit can no longer be regarded as being listed in 2A, inasmuch as the UK failed to adopt the measures.
That's right.
He said, the court says, suffice it to note the member state has in any event adopted the measures in question. So what's it really saying?
He's saying, I think, does that recollect? I think he's saying, because you haven't amended the old list in Annex 2A, it's too late, and effectively the Advocate General's analysis must now apply, which is that listing is defective and therefore doesn't operate for mobility components. You had your choice, suspension of temporal effects, you could have got your changes, and the court says, well, the changes have been made, but the changes have been made for the legislation that's now in force going forward. And effectively what they're saying is we're not in those circumstances going to insist on the nicety of the amendment of the old legislation, which has in fact been entirely overtaken by events in any event. That's what they're saying. So that is the last of the cases that deal with severance, with one exception that I should flag you, which is the CG case. Now, our primary position is that CG, a case my Lord Justice Green will remember from picking through it beforehand, is a case entirely about the meaning of social assistance under the Citizens' Rights Directive.
This is our tab 36, is it?
That's right. And it says nothing at all with respect about the concept of social security for the purposes of the coordination regulation. The one exception to that is paragraph 42 of the Advocate General's opinion, page 815, and the footnote to that. Because what is said in paragraph 42 is that it's common ground that it is lack of resources that forms the basis of CJ's application for universal credit for herself and her children, and that the benefit is classified as social assistance, and that must be social assistance for the purposes of the directive, because that's what she says, for the purposes of Directive 2004/38. But then if you look at the footnote, and the footnote comes after the words her children, As to what the expression universal credit covers, see AG 25 this opinion, it serves to designate a variety of allowances, some of which may be governed by special rules of EU law. That, we say, is plainly a reference to the coordination regulation. How do we say that? Because look at what follows. See, by way of illustration, Commission versus the UK at 27 and 55. And those are the very passages that identify the fact that the child tax credit element is an exportable family benefit.
Yes, but that's dealing with the child tax credit and not with the child element of universal credit.
But what, with respect, we think is tolerably plain, my lady, is what is being said is that there may be a case that the child element, the aspect of it for her children, is in fact an allowance which is governed by special rules of EU law. Why? Because it's akin to the thing identified in Commission in UK, the child tax credit, which is after all the benefit consolidated in the legislation.
So what legal status does the footnote have?
It's
The opinion.
part of the opinion, it's supportive of our case. It's not binding on you.
Right.
It's analytically useful, I think. Is
What's
how
the high point and low point of this brief reference? So you've got in paragraph 42, it is the point, the last sentence. The benefit should cover health expenditures not capable of altering that classification. I mean, where does this take either party in this case?
It's plainly a qualification. It's intended as a kind of footnote. Be careful, here be dragons, as to the proposition that it's social assistance more generally, because he's pointing out that a separate analysis may pertain under the coordination regulation, particularly in relation to the children element, because it looks like child tax credit.
She refers back to paragraph 25, which is just...
It's Advocate General de la Tour, Richard de la Tour, I think it is.
Oh yes, it's not good cost. Yes, well, I did that. Yes, of course it is. And paragraph 25 just describes the system and refers to the government's explanatory memorandum.
Exactly, which is all about the purpose of universal credit to consolidate and provide for a simplified, unified.
There's nothing in the court's judgment.
That's nothing at all. Now that, I don't want to oversell it. It's not conclusive, dispositive, but it's certainly distinctly supportive of the analysis we urge on the court. And it was, as I mentioned yesterday, cited to the judge below, and he didn't address it. And that is, we would suggest, unsatisfactory because of how it bears upon the question of severability. So that then leaves the Al-Hashem case. I'm going to let my learned friend open that. I'm going to very gently spike her guns, though, because I'm going to throw down 3 forensic gauntlets in relation to that case.
Sorry, which case?
The Al-Hashem case, the domestic case about...
Tab 38.
That's right. It's a domestic case about whether or not income-related employment support allowance, which is an SNCB for the purposes of the coordination regulation, was in fact a labour market access benefit for the purposes of the Citizens' Rights Directive. There are 3 problems with my learned friend's reliance on this case. First, it's quite apparent from the very brevity with which it's dealt with by Lady Justice Arden in her judgment, that it was run as an afterthought to the main argument being the essential function of ESA income related was a work access, labour market access benefit. And that argument faced a formidable forensic difficulty that effectively it had already been identified by designation as an SNCB, that the purpose being addressed by that benefit was disability, invalidity, etc., and not job seeking, there being a separate job seekers income related benefit. So the first problem is it's run as an afterthought. The second problem is it was conspicuously weak because of the underlying nature of the benefit. And the third problem was that the test in Bartlett, namely the potential to create a discrete and freestanding benefit, was plainly an insurmountable one on the facts of this benefit. Why? Because limited capacity for work and limited capacity for work-related activities are positions on the invalidity or disability spectrum. And the purpose of the benefits is to promote, as much as anything else, upskilling on the person's part so that they move from one category to another and become capable of some forms of remunerative work. It's the purpose of the benefit to promote that movement from one category to another. And so the degrees of incapacity or disability for work are a spectrum which you can move in either direction in relation to, depending upon developments in your health, etc. And in those circumstances, it's obviously impossible that the Bartlett test could be met by creating a distinct benefit. And it's a long way from the facts of the present case, where there was a distinct benefit doing the distinct purpose beforehand. So we think Al-Hashem is a case that turns on its facts and really doesn't add to the analytical framework. So there we go. Where does this then feed into in terms of errors of law by the Upper Tribunal? I do accept that our grounds 1 to 3 somewhat run into one another. But there are a variety of errors of law in the Upper Tribunal's approach, and it is perhaps convenient to take them as identified by our grounds in turn. The first, addressed by ground 1, is that effectively the judge invites you and does, and the Secretary of State does, to start by looking at the universal credit as a whole, based upon the features of national legislation that show that in national law it's treated as a single benefit. And that's all the passages identifying the unifying purpose of universal credit to introduce simplicity, refine the means test, etc. And in so doing, it ignores the approach of the CJU to address benefits that have one or more distinct objects and or may be capable of severance. And there is evidence in the judgment, no real attention upon the forensic consequences of the history of the 6 predecessor components of universal credit. That point really doesn't figure and isn't grappled with at all in paragraphs 47 to 48. And in particular, as we explain at 28, the analysis is coloured by the error of law I identified yesterday at paragraph 32 about the touchstone. There is no such touchstone. It's compounded by the failure to give any form of effect to the Dreyer and Commission and UK line of case law that says means testing, tapering, all of those types of provision directed at calculation aren't relevant to categorisation. And that's an error of particular importance, the error at 28B, because it's the tapering provisions, the income provisions, etc., that are alighted upon as the change that justifies the conclusion that this mozzarella ball isn't identifiable in the salad, but has been melted on the pizza, which is effectively the essence of the judge's conclusion. It's that previously identifiable benefit has vanished into the cooked product of universal credit. And then with respect, the tribunal, as we identify at 28D, hasn't really grappled with the test of the substance of the discrete components and whether or not applying the Bartlett test they could be separate benefits. So that's the first sort of strand of error identified by ground 1. And that then feeds into ground 2, because effectively we say the fault here is the identification of universal credit as a whole as the benefit, rather than the separate child element.
Well, that's the point you've just made under ground 1.
It is, and as I accept, Michael, the points do tend to bleed into one another, because the whole severance issue is a kind of chicken and egg issue. If you can sever, then obviously the purpose of severance is to identify the component as severed and to apply the functional test to that component as severed. And really, the heart of the reasoning is 47 and 48, as coloured by the earlier legal reasoning. There is, however, one peculiarity of the judgment I forgot to draw to your attention yesterday, and that's paragraph 49, which is a pretty puzzling paragraph, where the judge says, page 98 of the bundle, tab 13, having come to the conclusion I have, I do not need to decide whether universal credit is a social security benefit or a form of social assistance for the purposes of Regulation 883/2004. Now, that is fairly mystifying with respect, because the whole object of the analysis at 42 through to 48 is effectively to say no severance is possible, and because no severance is possible, you look at the benefit as a whole, and the purpose of the benefit as a whole, applying the touchstone in paragraph 32, is the relief of poverty, and therefore it's social assistance, because it doesn't meet one of the objectives or risks identified in Article 3. But you can't have your cake and eat it in that way. You've got to nail your colours to the mast. If you're looking at universal credit as a whole, you have to reach a conclusion as to whether it constitutes social assistance or a coordinated benefit whose main object was addressing this risk. And it's a very peculiar coda to the judgment in our submission. And
You say what he should have said was, I've already decided it is social assistance.
how can it logically be any other conclusion?
It's got to be one or the other.
Exactly.
And if it's not a social benefit, it must be social assistance.
It must be. That must be right, because you must be looking at universal as a credit as a whole, because you've refused to sever it, or you've said even if you do sever it, it doesn't make any difference, which is what he seems to be saying at paragraph 44. But either way, the answer has to be it's social assistance.
Yeah.
And it does, with respect, speak to some form of forensic confusion on the judge's part and the unsatisfactory nature of the reasoning in question. There are other oddities that we identify in ground 2, not least the kind of the Bray investigation that goes nowhere. And we say the only safe way to treat the CRD case law is as entirely irrelevant. We're only concerned with social assistance under the coordination regulation, and whatever else is said in that context is obviously irrelevant, not least because in Commission and Parliament, they decided that the child tax credit was social security benefit for the purposes of the coordination regulation and social assistance for the purposes of the CRD. So it's obvious that the CRD analysis can't contribute anything at all. The error in relation to the treatment of Hughes at 32 that we discussed yesterday is obviously material, because if that's the Upper Tribunal judge's conception of the touchstone of what is social assistance, it's wrong, and it must therefore infect the analysis at 47 to 48. The case law actually shows that something that is directed at addressing one risk, here poverty, but also one of the coordinated risks under the regulation, is nevertheless a social security benefit. And were it otherwise, there would be no need for income-related JSA or income-related ESA to be listed as SNCBs. The very reason they are, the very reason the category has been invented is to address those dual function benefits and to stop them from being exportable. So we say...
So to go back to your culinary analogy,
yes.
You can take the melted cheese off the pizza and say, yes, it's cheese.
No, we say that this is a mozzarella ball and pesto salad, and you can still...
I know, but the judge has said, no, it's not.
Yeah.
It's the pizza, but you say, well,
No, it's a pest.
If you can separate the pizza into the different ingredients, you can look at the cheese separately.
We say the pizza hasn't been cooked
Yeah.
and the mozzarella is still on the pizza. Or more to the point, we say it's not a pizza at all. It's a mozzarella ball salad, and you can
It's
see the
operating
mozzarella
Chinese
balls in the salad. That's what we say.
Yeah.
But that is the type of test that we're dealing with. I'm afraid that is the degree of forensic precision that one gets from Bartlett. And the intellectually honest thing to do is to reflect and accept it's not, as articulated to date, a precise test. That's undoubtedly a function of the fact that everyone dealing with DLA thought it was the answer's obvious. The fact that the answer's obvious is obvious from the Commission's submissions in the Commission and Parliament, the way it's been treated. And we have to find out where this case is on that spectrum. Now, we say, given the history of CTC, and given all of its features that say that it's just completely visible in the salad in the way that it was previously, the answer's obvious here. But if you're not with us on that, then subject to the question of jurisdiction, the point is referable.
Yeah.
So that's the key issue, and that is, with respect, the only reasoning of the Upper Tribunal. The Secretary of State advances some additional grounds. I don't complain about there not being a respondent's notice. I couldn't give a monkey's about that.
Sorry to
But
interrupt,
they're-
you just
they're-
referred a moment ago to a spectrum, but where is the spectrum? You've got two cases where the answer's obvious.
Well, we've got three with respect, my lady, because I've accepted that Al-Hashem is at the other end of the spectrum and plainly fails the Bartlett test because it isn't something that could be sensibly identified as being scoopable out into a separate benefit.
Oh, I see. So you've got extreme ends.
You've got two extreme ends.
Right. Thank you. That's helpful.
And can I just be clear as to the legal analysis? So severability really has two important points. One, is it capable of being treated separately? But then critically, if two, does that then mean it confers an individual right?
Yes.
Without the latter, if it's just simply an instruction to go back to a member state to do something, it is the latter which then, the analysis of separability leads to reclassification of right as a benefit which is recoverable.
Absolutely right. And Bartlett illustrates that that is a real factor because the answer to the question determines whether or not Mr. Bartlett or Mr. Gonzalez or Mr. Ramos could export their mobility component having moved to France.
And it's those two elements in Bartlett, is it, in 31 and the last sentence of that relevant paragraph in 21, which you don't find in Commission and
That's
Parliament.
right.
That just simply said, send it back to Parliament. Here says, whatever happens in Parliament, it creates a right.
I'm not going to say that this is massively satisfactory case.
No,
it's not. But it's the two cases read together that lead to the inexorable conclusion that it will alter rights. It does alter rights. And that's why there are the arguments about the SNCBs and exportability, and we're having the same argument about exportability, but that turns upon whether it's a social security benefit or whether it's social assistance, rather than whether it's social security benefit or an SNCB.
And so that's why the reference, I think it's Article 4 of 1408/71 is important, because the court said it impacts upon that right.
Exactly so.
Which is the point of the extent to which exportability is taken into account under the old directive.
Exactly so. Exactly so. So, in terms of the Secretary of State's additional reasoning, I mean, their main case is the same case as the Upper Tribunal. It's all enmeshed, it's all embedded, it's all, the pizza's melted. It's that case. But there's an additional case, which is effectively, our life would be terribly difficult if it were otherwise. Doing this will create all manner of complications. Now, the first thing I should say in relation to that is we don't accept that as a matter of legal analysis. The legal analysis we urge on the court simply leads to the disapplication of Regulation 4 in the context of the question of entitlement. It doesn't lead to all disapplications of all considerations about whether or not the child is in the household, so that for all purposes, housing, benefit, etc., the child is to be treated as cohabiting. Why? Because in the context of the housing element, we're not, in that sense, dealing with a separable child benefit. We don't make that argument. So that the scheme can continue just as it would otherwise. And that's really the answer to the scare the horses points made in paragraph 29 of my learned friend's skeleton argument. The bigger scare the horses point is, well, if this is a coordinated benefit under the regulation, we're going to have to apply the overlapping benefits provisions. We're going to have to investigate whether or not we're the competent state. And if we are the competent state, we're going to have to investigate whether or not in Slovakia or Spain or wherever else it may be, you're in receipt of a family benefit. That's the kind of CW case. Do you remember where the question was the German benefit social assistance or a family benefit, and did it operate to reduce the amount of the French allowance? And the answer to those concerns are twofold. One, they're utterly irrelevant. If that is what the law requires, that is what the law requires. If it's a coordinated benefit, you have to do your job. But the second answer is, with respect, we think that this is grotesquely overstated. And the reason I can put it as high as that is that child tax credit is an exportable benefit with almost identical characteristics. Presumably, those very issues have already been settled and addressed by HMRC in its administration. HMRC must have a settled view as to when it's the competent authority for that family benefit, and it must have a settled view as to what the other family benefits that are potentially being received from someone who is exporting child tax credit. And remember, child tax credit is not historic. It still continues to be operated. It's a diminishing legacy benefit, but it's still extant. I don't know how many claimants there are. How is it that HMRC can do that function and DWP can't? It's just inexplicable. And I'm afraid that is a scare the horses point of the kind that the DWP does make from time to time. It looks impressive on paper, but with respect, we can't understand how it can be true. Then you have the next iteration of the argument, which is, well, if we had to do this, we're going to have to make big changes to the universal credit computer and the algorithm that it uses and the unified decision-making it entails. And again, my answer to that is, I'm afraid if that's what the law requires, then tough. It's as simple as that. You can't use administrative considerations and the complexity that arises from the law being as it is and requiring what it does to game the operation of what the law is. And all of those arguments are bad in our submission. The only argument in play is the argument of law identified in paragraph 47 and 48. So that's our short answer to those points, and if they're persisted with, I will address them further in reply. That then leaves my last topic, reference to the CJEU. I think you very substantially have my points in relation to this already, so I don't want to gild the lily. And the reason I don't want particularly to gild the lily is we've set out our purposive case very clearly, and you've seen how it's reinforced by Article 36 of the Withdrawal Agreement. And I had a discussion with the court on the factors pushing towards purposive interpretation yesterday. That's precisely the position we urge, and we say the point is referable in and of itself as to the scope of Article 158. The reason I can't take it any further is my learned friend's skeleton argument does no more than articulate the narrow textual reading of Article 158. And we accept there is that narrow textual reading available. What her skeleton doesn't, with respect to, is in fact engage with the purposive interpretation and explain why it's not permissible, why it's wrong, and why the evident lacuna that this would produce, the hole in the middle of the donut, as I called it yesterday, fits with any teleological or purposive view of the provision in question. It leads, we say, to something that is an evident nonsense, that you have referable questions under the regulation up to a certain date, referable questions if you're lucky enough that the facts of your case all start after a certain date, and some kind of unprincipled hole in the middle. And anyone who is familiar with the EU's obsession with substance, not form, is going to think that that's going to be a hard argument to sell to the CJEU in my submission.
Sorry.
There was one question that was raised when we were discussing the case amongst ourselves, and that is the withdrawal agreement to be interpreted by reference to EU law or the Vienna Convention or something else?
The guiding principle is, in my submission, the principles in Part 1. and they apply just as
In
much.
other words, it lays down its own interpretative principles. Is that the point?
Well, the point is this: if my lord goes back to the withdrawal agreement,
Yeah.
I can't remember which tab it's in now. 17. Perhaps starts with Article 158 itself. Start with the language of 1581, which is the court may request the Court of Justice of the European Union to give a preliminary ruling on that question. A preliminary ruling is a term of art from EU law. And then you see 2, the Court of Justice shall have jurisdiction to give preliminary rulings. The legal effects of those shall be the same as preliminary rulings given pursuant to Article 267 TFEU. Look at that text together, and it's the clearest of renvoirs to conceptions of EU law and procedures of EU law. Then go back to the beginning, part 1 of the withdrawal agreement, and ask yourself, does the interpretation of Article 158 fall within Article 4.3? Is it a provision of the agreement referring to union law or to concepts or provisions thereof? And the answer is, obviously, it is. It's effectively extending the Article 267 procedure with adaptations, the principal adaptation I mentioned yesterday being the lack of a mandatory reference in a final court. And therefore, you're required to interpret and apply those provisions, that's Article 158 itself, in accordance with the methods and general principles of EU law, of union law. And so,
Yes, so that's if you get as far as interpreting the EU regulation, but
well, no, that's
does that
also,
apply to the withdrawal agreement as well? That's the question.
oh yes, this is directed at the interpretation of the entirety of the withdrawal agreement. This obligation in Article 4 applies to all parts, not just Part 2. It applies to Part 6, in which Article 158 appears.
I mean, it's the broader answer. We had this in AT, that it's because it's an international law agreement. It's covered by Articles 31 and 32 of the Vienna Convention, but they themselves permit you to construe it in accordance with
The treaty.
methods of interpretation set out in the agreement.
Yes.
So Article 31 simply takes you back to this. This tells you what you should be looking at.
That's right. Article 31 and 32 are the lex generalis. They're how you approach treaties in general. Here, you have a treaty that has its own reference to systems of law that explains how it's to be
That's
interpreted.
because Article 31 and 32 recognise lex specialis.
Exactly. Exactly. So the lex specialis here is Article 4.3, which bites on Article 158 just as much as it does on Article 31. I hope that answers my Lord's question.
It does, thank you.
Can I just ask a further question on this point?
Of course, my lady.
The time limit in Article 1581,
Yep.
in the case which commenced at first instance within 8 years from the end of the transition period, blah, blah, blah. That piece of text, is that union law or is it the text of the international agreement?
That is the text of the international agreement. I accept that.
But you say to be interpreted in accordance with union law.
Yes, because it's an addition, an adjunct to a reference procedure, and
Yeah.
you have to ask what the purpose of the reference procedure is, and the purpose of the reference procedure is in the period up to and ending at 8 years from the end of the transition period to ensure that Part 2 in particular continues to be interpreted just as EU law would require, because that's really what's going on. Those bits of EU law that are being saved should mean what they always mean.
We have the added complication that so far as the United Kingdom is concerned, we only treat this as international laws bringing in European law. In Europe, they treat this as both international law and EU law.
Yes, there is that added complication. That takes you back to...
But the reason why you have Article 4 and the principles of interpretation is to guarantee that if this agreement is construed in the German courts or French courts, every court, including the UK, will apply precisely the same interpretation.
Absolutely, and that is the topic that's in part addressed by the other provisions in Article 4 that both my Lord and Mr. Justice Chamberlain, sitting in the Upper Tribunal, looked at. This potential of identicality of interpretation in Article 4.1. So Article 4.1 of the Withdrawal Agreement is not just, as had been argued by Ms Smythe and then Mr Coppell before the Court of Appeal, it's not just a direct effect provision, it's also a provision directed at ensuring that the provisions of the agreement produce the same legal effects in the EU and in the UK. So I quite agree. The only further point we would add to this whole issue is the impact point I mentioned yesterday. Impact is in the bundle at Authorities 25. The relevant passage, as cited in AT, is paragraphs 53 to 55, page 586. But it might actually be more useful to see my Lord's speech in AT, which is at tab 43, page 1119. Paragraph 163.
Sorry, Mr. Delano, which tab again? 43, was it?
43, my lord. Page 1119.
And it was paragraph
I thought it was 163, but
163.
So that was about that was the adjunct argument that came up late about the allocation by the central government to the local authority.
that's right. And in answering the point, well, you've got these other remedies, you could go off and do these other things, I made the argument, well, this requirement to go off to 100 different places is inconsistent with the principle of effectiveness that says, see Impact Austria, that if you have a series of fragmented remedies, they can impede the effectiveness of the remedy. It's exactly the same analysis in my submission in relation to an interpretation of Article 158 that said, in effect, if you want to take an obviously referable point to the CJEU, you have to restart your dispute or restart your litigation after the 1st of January, because it's only in that way that you fall within the temporal scope. So, situation of continuing breach, you effectively have to restart the litigation once the breach continues into the 1st of January. And we say that's a total answer to all the points my learned friend makes about how national procedural law fixates upon the legality of the decision at the time it's made. That insistence that that be carried over to the question of referability is effectively an impediment to effective remedial protection for what is a continuing right to export the benefit in question. I've taken a little bit longer than I promised, but that will come from my reply time.
So in the case of Ms Simkova, if she said this is a continuing breach and brought the claim now,
Well, if she'd brought it after the advent of the withdrawal, her son has now left education, so her entitlement to export and to the payment of the allowance has gone.
expired.
Yeah.
But somebody else who was in a similar position.
Oh, of course. This point could be got back before the court if you said, well, it looks like a referable point, we'd refer it, but for the fact that we can't, the first person making this point in the first tier tribunal could say the Court of Appeal said they would have referred it if they could, now please refer it. And where's the utility of that? It's just a perfect illustration of how arid this argument is with respect.
Right, thank you.
Great.
Ms Smythe.
Good morning, my lord, my lady, my turn. I'm going to divide my submissions into 7 parts. I'm going to start by making some opening remarks and then a headline response to this appeal. Second, I'm going to set out some key propositions on EU law and benefits, and I won't repeat what Mr Delamere has said. Third, I'm going to look at universal credit. Fourth, I want to address the test for classification. Fifth, I want to address what's being called severability or severance. 6, I will address any specific submissions made by Mr Delamere that I hadn't addressed to that point. And then finally, I will deal with the question about a reference. So the first part of my submissions, which is in effect our headline response, can I make 5 points and then 3 points of context? So the first point is this, it's that the child element, or what we describe in our skeleton as the child amount, is not, as things stand, a benefit in its own right. What it is, unarguably under the legislation, is a calculation factor to determine the overall level of universal credit that somebody gets. Again, indisputably, there is only one benefit for domestic law purposes as things stand, and that benefit is universal credit. That's the first point. The second point is that it follows from that the success of this appeal depends on establishing that the child element is split off from universal credit and turned into a discrete benefit in its own right. Now, that's what the appellant is calling severance, and I will use the same language for simplicity, but to be clear, it's more than severance. What it's doing is turning something into a benefit on its own account, adopting the language of the ECJ and Bartlett, when it isn't one at the moment under domestic law. The third point, and we say crucial, is that one has to distinguish between 2 separate issues when one's looking at the case law. The first issue is the classification issue, and the second issue is what we're calling the severance issue. Crucially, we say they are 2 discrete issues, and case law about one of those issues is not case law about the other issue. Now, just to flesh that out, and this is important, we say that this is actually not a case about classification at all. And the reason is this, that there are 2 ways that a classification issue could arise in this case. One is looking at the benefit that there is, which is universal credit, and saying, is that benefit as a whole a social security benefit such that it is regulated by 883? But it's common ground between us that it isn't. So none of the cases, and I'll develop this, about dual function are relevant because we're all agreed that universal credit as a whole is not a social security benefit. So that would be classification issue number 1, but it doesn't arise. The second classification issue is classifying the child element if it's severed.
Well, does that amount to more than saying that Mr. de la Mare should have dealt with his questions in a different order and dealt with severance first, and then if it's severable, is the severed part to be classified?
If he'd argued it in that way, but what he's doing entirely impermissibly, we submit, is drawing propositions from case law about classification to support his case on severance. And one can't do that. The issue, the logically prior issue is, can the child element be split off and treated as a benefit in its own right, despite not actually being one at the moment?
Yeah, well, isn't that severance? Isn't
That's
that what
severance.
that's what he means by severance?
Yes, but what he does is draw on case law about classification in relation to severance. And so, for example, Dreyer, he's looking at propositions in Dreyer, which is actually a very specific case about one limb of the test for classification, and saying that supports his case on severance. And that, we say, is impermissible, particularly in this context where it's as complex as it is. One has to look at precisely what the case law of the CJEU is about. And cases on classification do not assist this court to answer the question of whether it can say, right, okay, child element is we're going to say child element is a benefit in its own right.
I think as I understood it, he was saying it helps you identify the characteristics of something which is capable of being separate, and therefore provides some gloss, if you like, or some guidance to the process. He doesn't say it is about severance. Does it not help us at least in trying to work out where the dividing lines between different components of an overall scheme might be?
Not. I may need to develop the submissions, and I think perhaps if I just make the headline point at this
No.
stage, no, it does not help, in the sense that this is a very novel argument. It's very different from Commission and Parliament, which has taken me into my fourth point. This argument is, right, this isn't something that you can claim in its own right. It's not a benefit in its own right, but the court should treat it as such. That there is not a single case on classification or otherwise which says that's what you can do. Now, Commission and Parliament, and this is my fourth point, at the moment the third point is essentially they are two discrete issues, and I'll show that Mr. Delamere has blurred them. But the fourth point is that Commission and Parliament does not come close to establishing that what is effectively a calculation factor can be treated as a benefit in its own right. The crucial point about Commission and Parliament, whatever the Delphic nature of some of the remarks, is that the court knew all along, from the beginning, when Commission and Parliament was before it, that DLA had two components which were separately claimable. What this appellant is saying is, well, I want child element to be a benefit in its own right, as it was before, so that I can claim it separately. So far as DLA was concerned, that already was the position. It's a crucial difference between this case and Commission and Parliament that the legislation, which was the same throughout this litigation, had always said each element can be claimed in its own right.
That is the domestic legislation.
That's the domestic legislation. So that's why the Commission says, well, these are severable. It knows that all along. So we say that what this appellant is asking the court to do is say, well, no, we know it's not separately claimable. We know you wanted to set up a global benefit, but you can't do that, actually, because you've got to split it off into different benefits. And we say that goes far further than Commission and Parliament, and it's fundamentally inconsistent with the whole grain of what is a coordinating measure. Because effectively, what the appellant is saying, and it is the logical conclusion of the argument, is, well, sorry, you can't have a global benefit like universal credit, because as soon as the amount changes by reference to something which falls within Article 3 of the regulation, that means it has to be treated as a separate benefit.
So he's treating a coordination measure as a harmonisation measure.
He is, and it's the tail wagging the dog. Different, as I say, because the DLA was already like that. Nobody had to change anything.
So this case is one step or two steps behind. I suppose it's comparable only in the sense that child tax credit is still recoverable as a legacy and form the basis of that component of UC. So it has that connection, which is not as strong as the case in Commission and Parliament, where there were two discrete recoverable elements. They're not a million miles apart, but they are apart.
They are in my submission, because child tax credit is not a component of universal credit. It's right that some features of the legislation were borrowed from and that it's very similar in many respects. But for present purposes, it's got nothing to do with universal credit. It's gone. Universal credit is premised on it being abolished. So yes, there are still some legacy claimants claiming it. But when the court is answering this question about universal credit, the history, we say, is irrelevant, and I'll develop that in my submissions. If it were otherwise, every time a benefit had to be classified, what you would do is pull out all the history and say, oh, well, bits of it came from this benefit, bits that, and the court has been shown many cases, there is not a single example of the court looking at the history of a benefit. So we say, irrelevant.
And presumably, to the extent that people are still getting child tax credit in legacy cases, they can still export it in accordance with
Yes, although they'd be fixed with the judgment in Carrington, because the
Right.
result of that is in reality not very many people can export family benefits.
Right, okay.
And I'll explain that in a moment.
But in principle. I
In
mean,
principle,
absolutely.
exactly, yes, but, and that would be, it's, what one has is the law responding to the domestic benefit, as one would expect with a coordinating measure, not the domestic system responding to the coordination legislation and effectively saying, and this is my fifth point, that simply because if you have a global benefit which goes up by reference to any of the things addressed in Article 3, that means you've got to sever it out, otherwise you're somehow escaping the social security coordination legislation. That's not, and I'll develop that now in my 3 points of context. So the first point of context is this, that Mr. Delamere used either the language of avoidance or evading in terms of universal credit and the social security coordination legislation. Now that is wrong. The first point is that the undercurrent of his skeleton was that if the court doesn't do what the appellant is asking it to do, universal credit somehow escapes the scrutiny of EU law. But that is wrong, as we've said in our skeleton. And I'll, for example, that the court will know that if one is in a member state, one can complain that not giving me that particular component is indirectly discriminatory on grounds of nationality and therefore needs to be justified. That law applies regardless of whether the social security coordination legislation applies. What EU law has in effect is different rules for different things. And if that EU law social security legislation doesn't apply, that doesn't mean that the domestic benefit escapes the scrutiny of EU law. Now, the appellant may have chosen not to put her case in that way, but she could have done. So that's the first point. And it's important in that context to say that when things are being cast around as avoidance or evading, that there are a number of other member states, so far as the Secretary of State is aware, which have benefits like universal credit, who no doubt would be quite surprised to hear, sorry, you weren't allowed to do that, you're going to have to split it into lots of different benefits. And we've given a couple of examples in paragraph 40 of our skeleton, but it's not avoidance, it's simply a decision to set up a benefit in a particular way. In the UK, for very good reasons, that we want a global benefit, it makes things easier. But that means, yes, it may mean the social security coordination legislation doesn't apply, but other rules will. So that's the first point of context. The second point of context is that we address what we say the consequences will be of all of this, and I will develop this in more detail, but as a headline point, what we say, that the appellant's argument is, well, too bad, that's the consequence of the coordination legislation, and we say that gets it wrong. We say once you look at the consequences, which is fundamentally that the domestic legislation needs to be redrafted, that illustrates why the argument is wrong. Because what it would mean is that despite it being for the state concerned to organise its social security system, it can't organise it to have a global anti-poverty benefit like universal credit. Now at that point, still in my introductory section, could I just invite the court to turn up the judgment in Carrington, which is at tab 42 of the bundle. I'm not going to go through all of this unless it would be helpful. When I come on to dealing with the regulation, we'll summarise what it says. But could I just invite the court to read the last 4 lines of paragraph 104 on page 1055, tab 42.
That's fine, that's which paragraph?
1055.
1055, paragraph 104, the last 5 lines,
Yeah.
sorry, not 4. And we say that applies equally here. In fact, even more so, given that what the court's being invited to do is tell the Secretary of State to rewrite her legislation and not have the benefit that she's chosen to have anymore. And then the final point of context is this, that it might benefit this particular appellant to have the child element split off and treated as a social security benefit in its own right, but there will be other losers. And so there'll be other losers, not just in relation to family, the child element, but also if the logic of the argument is right, then other bits need to be split off as well, and that will have other consequences for other people. So this appellant may say, well, I think it should be treated like this because it will get me an amount for a child not living here, but other people, we say, will lose their universal credit. So it's not a case where there's an answer one way or the other, and we've given an example in paragraph 34 of our skeleton. The fact is that there are winners and losers, and that, in our submission, the logic of the argument being, well, this is what you need to do and it's all too bad, one has to bear in mind that there are broader consequences than this court will be seeing based on the arguments. And indeed, certainly those instructing me who are experts in this particular area of social security coordination and have given a genuine assessment of what they say the consequences of this will be, are as yet still to think through, because it would have such consequences. So for Mr. Delamere, in my submission, to dismiss those very genuine concerns is simply wrong. So those are my opening remarks. Could I move then to the second part, which is to deal with some propositions to do with benefits and EU law? And just to start with a point about domestic social security law, it's addressed in our skeleton at paragraph 9, but I apologise, I don't think this provision made it into the bundle. It's section 12(8)(b) of the Social Security Act.
Sorry,
which,
isn't it? Paragraph.
it's paragraph
9.
9 of the skeleton, and the court may wish to keep that out or have a finger
Yeah.
in it, because I'll probably be referring to it several times. But what section 12(8)(b) says is that the appeal, the tribunal has to look at circumstances obtaining at the date of the decision, and it's established that that means legal circumstances as well as facts, and I don't think that's any dispute between us, and that's why we say this court is applying EU law. We also accept, as did Judge Jacobs, that social assistance means different things in different contexts. So it's got a very narrow meaning for the purpose of the coordination legislation, and it's got a broader meaning in the free movement context. And we've summarised the types of benefits available at paragraphs 13 and 14 of our skeleton. So at that point, could I invite the court to turn up now, or turn back to...
I'm so sorry, just the paragraph number of your skeleton, which gives an example.
Paragraphs 13 and 14 summarise the different types of benefits. In terms of the example of where somebody will be worse off.
No, it's that latter example.
Oh,
yes.
paragraphs 13 and 14.
Yes, that's right, I've got that. Yes, you've given paragraph
Yes.
9 as the example.
Yes, paragraph 9 is 12(8)(b) and 13 and 14 is simply a summary of the types of benefits. But we accept, just to be clear, that there are two different meanings of social assistance. So at that point, could I invite the court to turn up the regulation, which is at tab 14.
14.
Tab 14, page 253. Starting with recital 4. Which says, it is necessary to respect the special characteristics of national social security legislation and to draw up only a system of coordination. And the appellant's case does not respect the way that the UK has chosen to set up its system, because it's chosen to implement a global benefit, and effectively the appellant says no, deconstruct it and go back to the system that you had before. Now, in terms of the general principles in relation to social security benefits, we've set those out at paragraphs 15 to 18 of our skeleton. And just for the court's note, in relation to this point about harmonisation, the court has already been shown, and we don't need to go back to it, Commission and UK, but paragraph 67 deals with this point about it not being a harmonising measure. And then the reference we've given in our skeleton is the case of Stewart. Again, just for the court's note, we've given the
Sorry,
reference.
where is Commission and
So,
no,
I'm
which
sorry,
one?
I'm going too fast.
Yes, you are.
I am. Commission and let's turn it up for simplicity. So Commission and UK,
Yeah.
which is at tab 31.
This is under your heading, not a harmonising.
Not a harmonising measure, exactly. If the court turns to page 750, paragraph 67, there's a neat encapsulation there of the principle.
Some of us are not quite as familiar with this area of law as you are, Miss Smythe.
Yes, your lordship is most fortunate in that respect, if I may say so.
It's fascinating.
Mr. Delamere disagrees. We love it really. So that's just for the court's note. That's an encapsulation in the case law. So coming back to the regulation at tab 14 and respecting the special characteristics of national social security legislation, we accept, of course, that whether national law describes a benefit as a social security benefit or not is immaterial to the question of whether it's a social security benefit. But otherwise, what one sees from the cases is that you take the benefit as you find it. So turning then to Article 3, which is matters covered, the following branches of social security, and there are, as Mr. Delamere said, a number of different things there. And if you look at them, they are various ways in which a member state with a global subsistence benefit might decide to calibrate the amount of it. Covers sickness, maternity, invalidity, unemployment, and family benefits. Now, the word I would emphasise in each and every limb of that is benefit. And we say it has to be a benefit in its own right. Whatever it is, it has to be a benefit.
By which you mean what?
Universal credit is a benefit. The two components of DLA were each benefits in their own right. Child element is not a benefit. So this court being asked to turn it into one.
So benefit means what? A discrete entitlement.
It means
I mean, it's beneficial to Miss Simkova in a broad sense if she were to get the child element of universal credit. But you obviously mean something different by
Yes.
benefit.
So let's compare universal credit. The benefit is called universal credit, and I'll take the court to the legislation. The legislation says there is a benefit called universal credit. So that's how the European Court would start by looking at it. What does domestic law say is the benefit? It says it's universal credit. When it looked at DLA, it looked at the fact that it says there are two components and you may be entitled to
Yeah.
one and not the other.
Yeah.
Not the case with universal credit. You can't pitch up and say, "Oh, I'll just have the child element, thank you very much." So, well, you either claim universal credit or you don't. So the child element's not a benefit. It doesn't look like a benefit, isn't a benefit, it's just something that calibrates the amount when you're claiming universal credit, in the way that many of those Article 3 risks, as the court calls them, might affect the amount of a global subsistence benefit.
There's no definition of benefit per se as to whether it's factual or legal.
No, there used to be in 1408. I can't see that there is one now, although when one looks at Bartlett, and so far as this context is concerned, it asks the question of whether it's a benefit in its own account or on its own account. It's usually pretty obvious to the court that something's a benefit or it isn't, because what the court does in all of these cases is says, right, this is what the national legislation says, this is what it's called, and then it goes through the conditions in national legislation. So if there is not national legislation saying there is this benefit called X, then there isn't a benefit. I mean, that's simply the way that it's analysed.
In Article 3.1 is benefits are referring to a branch of social security.
Yes, so they're, because of all those different, it's odd because it describes them as risks, but it's because it's concepts of insurance. So what the case law says is, well, that's a benefit that relates to this specific risk. So if for example, there was a case in this court called Conavod, where Mr. Conavod went off to live in Cyprus and then became unwell. And he said, well, I should still be able to claim a sickness benefit from the UK because I paid lots of money to the UK. And the Secretary of State said, well, no, that's not right. You've moved now and a different law is applicable to you. So the risk of sickness has materialised in the new state. So in that case, this court agreed and said, yes, you've got to make the claim to your new state. So that's a branch of Social Security. It is Social Security dealing with the risk of sickness. I mean, one might say dealing with the risk of having children. It's sometimes a slightly odd word. Or dealing with the risk of becoming unemployed. That's the way that the cases analyse it. And
if you're right, does it necessarily undermine the notion, assuming there is a concept of severance, that exceptionally you can create new branches or benefits because something meets a sufficiently strict test of severance? Does it necessarily undermine your principle? Is it meant to be the exception which proves the rule?
well, what the case law says is that this is comprehensive, but Mr. Delamere's case, in fairness to him, is that if you sever it, it's a family benefit. So what, and I'll show the court Herx in a moment, what the court says is a global anti-poverty benefit isn't within Article 3 because it isn't covering one of these specific risks. But this is about benefit, this regulation, and there are reams and reams and reams of cases that between us, Mr. Delamere and I, have probably barely scratched the surface of in our working careers, which address these specific areas. So the case law on sickness benefits will be very specialised. The case law on invalidity benefits will be very specialised. The rules are very specialised, as Mr. Delamere said. What you don't have is anything in this regulation about, well, what if something's just a general benefit? How does the coordination legislation work? The answer is, well, it doesn't, because that's not what it does. It deals with very specific benefits. And because it's so complicated, it has to have very tailored rules for very specific benefits.
Your essential point is once you, and I don't mean this at all in the derogatory sense, once you apply a global wrapper to create a unified benefit system with a single payment at the end of the day, that just simply takes you out of the scope of Article 3.
It does, yes. We would take issue with the word wrapper.
I understand. I mean, a global benefit which has a number of components all leading up to the top of the pyramid, which creates a single figure.
Exactly, that's exactly right. So just so that the court understands, because there have been lots of questions about exportability and family benefits, could I just show the court Article 11, which was partly what the case in Carrington was about. It was also about Article 7. Now, Article 11, this is Title 2, Determination of the Legislation Applicable. This is the core of this regulation, because this if I decide, right, had enough of the UK, had enough of social security coordination, off to go and live in France, I will need to know at any given time which social security system applies to me. What's the legislation that applies to me? And Article 11 will tell me that. It tells you which is the state to which you need to pay social security contributions, and it tells you which is the state to which you look if one of the risks in Article 3 materialises.
I notice that Article 11.2 uses the phrase cash benefits.
Yes, that's quite complicated, but it covers more than your lordship might think. What it's doing is distinguishing between cash benefits and benefits in kind.
Yes, which benefits in kind have been defined earlier on.
Yes, cash, but we're dealing with cash benefits here, and things like DLA and PIP are cash personal independence payment are cash benefits. So just to understand how it works with exportability and family benefits, there's a default rule in E which says if the provisions in A to D don't apply, the default provision is that the legislation of the member state of residence is applicable to you. And one of the core provisions is in Article 11.3a, and that says if you're working somewhere, it's the state of work that applies to you. Now, we haven't, in relation to Ms. Simkova, investigated what this question at all, but we're not at the moment saying the UK law isn't applicable to her. But in terms of understanding how it works with family benefits, the outcome in Carrington was that you look to the state of applicable law for your family benefits. So if you're claiming child benefit in the UK and you move to Spain and Spanish law becomes applicable to you, Spain needs to provide family benefits to you. And if Spain doesn't have any, that's just a consequence of the coordination legislation, because a move isn't necessarily neutral. So that concept of applicable law is very important so far as family benefits are concerned, because the row in Carrington was about what Miss Carrington said is, well, no, I can keep my child benefit even though I've moved to Spain. In other words, I can export it, and the court said, no, you can't, because once the legislation applicable changed to Spain, which it did once you became resident there, see Article 11.3e, you have to look to Spain for your family benefits. Now, the striking point about Carrington, and it's an important illustration of why there's a danger in looking at cases on one issue to help with another issue, is that that position is completely different for sickness benefits. Because for sickness benefits, you keep them even if the applicable legislation changes, which was something that the court had to grapple with in Carrington. And I flag that and support Mr. Delamare's point that the rules in Title 3 are very detailed, very technical and complex. And it's common ground between us that you can't have a benefit simultaneously being a benefit of all these different kinds, which is why he is forced to say, well, okay, you just need to go back to the situation you had before, which is that you had a separate family benefit rather than calibrating the amounts for the purposes of universal credit. So that, I hope, answers, I think your lordship asked, was it common ground, what Mr. Delamere had said about Article 67? In a sense, but it's only exportable if the state of applicable law hasn't changed. And in most circumstances, one would think it would do, because it changes if you move somewhere to work, and it changes if you just live somewhere. So it isn't, one has to understand exportability of family benefits in the light of Carrington. It's actually, this isn't a case about exportability at all. It's a case where somebody's saying, well, there's a bit of money I should be getting that I'm not getting because my child isn't resident here. She's not asking to take it with her anywhere. It's not about exportability. It's saying, what I want you to do is apply a rule in this regulation to strike down a provision which is stopping me getting money simply because my son is living in another state.
Yes, I mean, if she gets the money, it's up to her what she does with it.
Well, yes. We would know if one reads Carrington, the court itself acknowledges what I think Sir Lancelot Henderson describes as daunting complexity, and I think he says it on a number of occasions, and sounds a note of caution about taking things in case law out of context, and we sound the same note of caution here. So wrapping up on my second section, could I make 2 points, although one of them I'll be testing the court's patience because it's a repeat. It's that this is specialised technical legislation and one has to be very careful to look A, at what the cases are dealing with, and B, what the facts are. And second, and importantly, and this isn't the point I've made, what the appellant is suggesting is very significant indeed. As I've said, what in effect she's saying is, well, I'm sorry, you can't have a global benefit like this because that means you're evading the coordination legislation and it's got to be divided into different parts. Now, given that these benefits, it's not simply unique to the UK, other states have them and had them before the UK did, we say it's striking that there is nothing whatsoever in this regulation saying, and if you've got a benefit like that, you have to divide it up into different parts so that this legislation applies, because it's such a major thing to do, effectively to say to a member state, well, you can't do that, or it needs to be split into different benefits, and necessarily one that has consequences. It's striking in our submission that there's nothing in the regulation about it. The reason that there's nothing in the regulation about it is because it's not what this legislation is about. It's not concerned with global benefits like this. Claimants of those benefits get their protection for elsewhere. So we rely on the fact that there isn't anything in the regulation about it. If it had been intended...
So in short, you say this is about the coordination of social security systems as they are designed. It is not a regulation about how to design a social security system.
Precisely. Your Lordship has put it much better than I did and much more quickly as well. So yes, so the third section is then just to deal briefly with universal credit, and I will ask the court to turn up some policy material. Starting at tab 44 of the authorities bundle, tab 44, page 1130. And just above the bottom hole punch, there is a statement that if this is a white paper about universal credit, it says here, we are embarking on the most far-reaching programme of change that the welfare system has witnessed in generations.
Sorry, what page are you on?
1130, paragraph just above.
Yeah.
It's the
Yes.
bottom of that paragraph. And then at paragraph 3, there's a sidelined passage. And about halfway down paragraph 3 on page 1131, it says, there was general agreement on the need for reform, with strong support for our objectives of streamlining the system and making work pay. The majority of respondents who commented on the specific options for reform recognised the attraction of moving towards a single benefit. And then at the top, the Institute for Fiscal Studies, there are substantial advantages to having a more integrated benefits and tax credit system. Blah, blah, money lost to fraud and error simpler for recipients to understand. We consider there to be a strong case for integrating all benefits and tax credits into a single benefit, and that is what universal credit does. the whole purpose is to have a single benefit and not several. And then, just for the court to know, there is a section on page 1136 which deals with why we need reform. The headline really is paragraph 5, that there's an array of benefits, each with its own rules and criteria, interacting in complicated ways, creating perverse incentives and penalties, confusion and administrative cost. And then in tab 45, there's an impact assessment, and it's got 2 boxes. In the first box, what is the problem under consideration? Why is government intervention necessary? There's a repeat there, 4 lines from the bottom, of a complex array of benefits, interacting in complicated ways, creating perverse incentives and penalties, confusion and administrative costs. Now, it goes without saying that these are necessarily policy matters for this country to consider, given the needs of its population and so on. And then, just for the court to know, what are the policy objectives and the intended effects? Again, restructuring the benefit system. So that, in a nutshell, is the reason for introducing a global benefit. The court won't find anything in any of this saying that this is about trying to avoid the consequences of the social security legislation because we don't like its consequences.
And I see that what it describes as the policy objective is to create one single income replacement benefit for
Yes.
working age adults.
Exactly, and it is about doing that. It's about delivering subsistence benefits in a completely different way. And the case law describes it, for example, as revolutionising the benefit system. That's Lady Justice Andrews in the Salvato case, which the court has at tab 41. And she describes it as a radical reform. She describes it as one holistic benefit. And in that case, Salvato, and I won't take the court to it because of time, but it's at tab 41, paragraphs 1 to 5 that we've sidelined. Lady Justice Andrews describes the practical difficulties of trying to untangle or undo the way that universal credit is set up, albeit I accept in different context.
Yeah.
But the thrust of that passage is it's one holistic benefit, and if you start pulling one, I'm not as good as Mr. Delamere with my analogies, I'm particularly not a good cook, but if one starts pulling one strand, says he
Trying to
who's-
extract the soy sauce from the Chinese fried rice.
Yes, I go nowhere near the kitchen. But as soon as one starts trying to extract one strand, thinks, well, we could just do that. It has all sorts of unforeseen consequences because this took a lot.
That game where you pull sticks out.
Yes, I was never very good at it.
Kaplunk.
Kaplunk. Or operation. So that's the point. That there will be unforeseen. If Mr. Delamere says, well, just give her the money. It's not that simple.
Yeah.
It's very carefully calibrated. So the court has, I think, already been taken to the provisions of the 2012 Act. So I won't do that again in any detail, but could I just ask the court first to look at section 1, tab 4, page 30. Section 1.1, the very first thing this Act says is a benefit, known as universal credit, is payable in accordance with this part. It is one benefit. The legislation reflects that. Compare and contrast the legislation for DLA, which works very differently. And then the court has seen the way that it works. It's the key provisions of sections 8 to
David,
section.
your entitlements dealt with by section 3,
Yes,
and one of those conditions for entitlement is the financial conditions.
yes. So the basic conditions in section 4 and then the financial conditions, which are section 5. And they are mainly prescribed.
So that's you've got capital or income lower than a prescribed amount.
Yes,
Effectively.
and needless to say, that's
So-
quite complicated.
Yeah. But the essential point there is you haven't got enough to live on.
Yes, it's a new way of delivering subsistence benefits, essentially.
Yeah.
But in
And,
one package.
Could you just tell me a little bit about section 12, which ties in with section 1(3)(d)? What are these other particular needs or circumstances that they're talking about?
Yes, so 12(2)(a), limited capability for work and work-related activity. So somebody may have limited capability for work but still be able to do certain work-related activities, and that was looked at in the Al-Hashem case. That was a division in the old employment and support allowance. Somebody who had limited capability for work-related activity wasn't even able to do things like preparatory steps and so on. So that's then that the amount can be calibrated for that reason in addition. And then similarly, if somebody has regular and substantial caring responsibilities for a severely disabled person.
How much you get would still depend on what Mr. Lemaire calls an algorithm, would it? Rather than
Yes, it's all, I'll turn my back, but it's all spelt out in legislation.
Yeah.
Yes. To be clear, we do not suggest that this is social assistance in the narrow sense referred to in the coordination legislation, because it's not discretionary.
either you're entitled to it or you're not.
And two people in precisely the same circumstances, which would be quite difficult to find two people in precisely the same circumstances, but suppose they were, they get the same amount. It's not the case that there's a board sitting there deciding that person A can have £100 and person B can have £200, which is more the classic social assistance so far as the regulation sees it. So it's regulation 36 of the 2013 regulations, which sets out the relevant amounts that one gets for all the different elements. And I can give the court page number for that.
Can I just take you up that last point?
Yes.
It's not social assistance. You just say it is social security, but it's just not within Article 3.
Well, yes, one has to be quite careful because the cases seem to analyse it in different ways. I can't remember which case talks about it's not enough for it to be a social security benefit if it doesn't cover one of the risks in Article 3. And in that sense, one is social security is anything which isn't social assistance. In other words, it's something which is given on the basis of a legally defined position. So one has to be careful about what one means about social security. The cases on classification have that two-limb test, which is to say one, I'm going to misquote this unless I read it word for word, but the way that we've analysed it is to say it's only a social security benefit if A, it's granted without an individual and discretionary assessment of personal needs on the basis of a legally defined position, and we accept universal credit satisfies that, and I'm reading from paragraph 42 of my skeleton. And second, that it concerns one of the risks expressly listed in Article 3. So whether you say it's social security because it's granted without an individual and discretionary assessment of personal needs, but it's not caught by the coordination regulation because it doesn't cover one of the risks, or whether you just don't describe it as social security because it doesn't meet those two conditions, the outcome is the same in effect.
So, going back to your skeleton, the question or the condition you pose at 42.1 doesn't really go anywhere.
Add anything? No, the reason I did that is just because it's what the legislation says.
Well,
but
the
actually
legislation puts it last.
Yes, I accept it doesn't add anything. It's the flip side, really, of 42.2.1, if that helps.
Yeah.
I mean, one sense, it's dangerous to get sucked into terminology.
It
and
is.
labelling. Your point simply is it's not within 883, whatever it's called.
Yes, and it tends to be, certainly in government, that things get called social security if they are within 883, because then everybody knows what they're talking about, and there isn't that fine distinction of, well, it could still be social security because it's granted without an individual and so on. It's really, is it caught by the regulation or isn't it? And as your lordship rightly says, that there are problems of terminology, and there are problems of terminology in the case law, as one would expect in a regulation of this complexity. I mean, it's right to say that one can't always marry up the cases of the ECJ, which is why one has to look at the fact of them. It's immensely complicated.
Just out of interest, what is it labelled as? I mean, UC is huge, it's vast. How is it labelled?
Universal credit.
Yeah.
In
As social security, or as just benefits, or
the department would describe universal credit as social assistance, but that's because it so far as the department is concerned, it's simply outside the scope of 883, and it certainly is social assistance in terms of that broader definition of social assistance, which is in relation to the citizens' rights provisions, and indeed the court accepts that in CG.
but the question for us is not how anybody labels it. It's how it's structured and whether it fits within 883 or not.
Yes, and the answer to that is it doesn't, because it doesn't concern one of the risks
No,
expressly
absolutely.
listed in Article 3.
That's because it isn't a benefit. I mean, it isn't the benefit which is referred to in Article 3.
Yes, it's not a benefit addressing one of those specific risks, it's a global anti-poverty
Yes,
benefit.
yes.
Yes, and I'll come on to that in part 4. So
essentially you say it's to give people a minimum income, but what that minimum income will be in any particular case may depend on the circumstances of that person, including their housing costs, childcare and all the rest of it.
absolutely. And the fact of having a child has an impact on things other than simply the child amount being sought in this case, because it has other consequences. And we've addressed that in our skeleton at paragraphs 28 and 29. And perhaps that's just a useful point to pick that up. So paragraph 28 says that paragraph 28 sets out regulation 4, which I think the court has already seen, and then 28.2 addresses quantum. For the court's note, all of those provisions referred to in paragraph 28 are in tab 8 of the authorities bundle. But the point is that if a universal credit claimant is responsible for a child, it doesn't just affect the child amount or the child element, it also has some other consequences, and we list those at 29. So it's part of the test for identifying how many rooms are included in the calculation of housing costs, and we've cited the provision there. In the interest of time, I won't take the court to it, but it's at pages 126 to 18 of the bundle at tab 8. So even though Miss Simkova doesn't have a child living with her, the consequence of her argument is that she's also going to get an extra room. Now, Mr. Delamere will say, well, we'll just have to set the legislation up differently then, because otherwise, but our answer to that is, okay, yes, we'll need to amend it though, if you're right, which is exactly what we can't be required to do, because this is a coordinating measure. It would need to be amended because otherwise somebody in that position would get too much money. Similarly, it affects eligibility for the work allowance. That's page 107 of the bundle, and similarly it can affect work conditionality requirements. So supposing somebody is here and they have a child under 1 but living in a different member state, they would still be subject to different work conditionality requirements, notwithstanding that the child was living somewhere else. So all of that would need to be unpicked. Legislation would need to be redrafted. And this is our point about the calibration and the interlocking, because it's one global benefit. And it's no answer to that, so, well, you just have to amend legislation because that's our tail wagging the dog point.
I guess it does depend what's tail and what's dog.
Yes,
If
but
he's right, then you've got to do it because that's just the law, you accept that.
Except
But you
that,
say that your starting point is the recitals you've shown to us, the provision which says everybody's entitled to their own system. So that's where
Yes,
that's what you
and-
say the dog is.
yes, and I think the headline point about Commission and Parliament, again, whatever the oddities of how the court phrased it is, no legislation ever had to be amended, nothing had to be changed, it all worked. And we say that's simply what the court was reacting to. This is very different. This is taking it far further. It's saying, sorry, you can't really have a global anti-poverty benefit like this. You're going to have to design it so that it falls within the condemnation legislation, and that is not what happened in Commission and Parliament.
Yeah, well, if there was one tabloid headline to sum up your submission, that's it, isn't it?
I'll sit down. Thank you very much. So just drawing the strands together in this third part of my submissions, we say that all of this means it isn't what's being described by the appellant as a wrapper or an umbrella. It's actually a radical new way of delivering a subsistence benefit in the form of a global indivisible benefit. And I've already referred to the comments of Lady Justice Andrews in Salvator, and my Lady Justice Elisabeth Laing also we footnoted in our skeleton, the Pritchard case, which also refers to this as being radical new way, but that's what it is. So moving then into the fourth part of my submissions, which is dealing with what I say is a very discrete issue about the test for classification of benefit. And we've already looked at paragraph 42 of our skeleton. Just to be clear, I think we've already addressed this. There are two conditions spelt out in 42.2 and they both need to be met.
Well, there may be an anterior question. What are you classifying?
Yes. Well, that is the question in this case, because unless you split it off, what you have is a benefit called universal credit. Because if there were a reference in this case on any issue, the court would, one imagine, start by setting out the legislation, which is there is a benefit called universal credit, and the court would be dealing with universal credit. That's what we're dealing with. So that's why I said at the beginning, is there really a classification issue in this case? No, because nobody's saying universal credit, which is the benefit in domestic legislation, needs to be a family benefit. Mr. Delamere accepts that's not right. So the court isn't being asked to classify universal credit, the benefit that is. It's being asked to carve out of it something that's a calculation factor and turn it into a benefit in its own right. That's not classification. That's what Mr. Delamere describes as severability, and I'm using the language, but I'm going to call it, as I did earlier, turning something into a benefit when it isn't.
Yeah.
So there isn't an issue about classification of the benefit that exists under domestic law. So the points about, well, there are cases like Hughes and INPS which say a benefit can have mixed functions, don't really go anywhere, because unless the argument is, well, universal credit's doing lots of different things and it might have an anti-poverty function, but it's also got a family function, so therefore it's a family benefit, but it's not being argued that that's the case. So cases about dual function in terms of classification aren't actually relevant unless that argument is going to be made, and quite likely it's not. So could I then invite the court to turn up the case of Herx, which is at tab 18, and the proposition I'm going to take from this case is that a global anti-poverty benefit like universal credit is not a social security benefit. So tab 18, this is about entitlement to a benefit called the Minimex, sorry. That was just a slip of the tongue. 353, which is the Advocate General's opinion, is the facts, which is the plaintiffs. The bottom of 353 applied for the grant of a subsistence allowance, the minimum means of subsistence, known and hereinafter referred to as the minimex. And then one can see that paragraph 3 of the Advocate General's opinion, in between the two hole punches, there is a condition that the person must be prepared to accept work, except on health grounds or for other reasons. And then it's a means tested benefit. That's the paragraph below. And then turning to page 363, at paragraph 9 is the question.
So now we're in the judgment.
We're
yeah?
in the judgment, yes,
Yeah.
I'm sorry. 363. Question 1 essentially asks whether a social benefit guaranteeing a minimum means of subsistence in a general manner, such as that provided for by the Belgian Act of 7th August 1974, falls within the material scope of 1408/71. Then we see at paragraph 11 the classic formulation, which is the distinction between benefits which are excluded and benefits which come within it rests on the factors relating to each benefit, in particular its purpose. And we say that does allow the court to look at the purposes behind the benefit and the conditions for its grant, and not on whether the national legislation describes the benefit as a social security benefit. So all that that's saying is you can't set up a benefit and say this is not a social security benefit for the purposes of 883. It's not saying, and you can ignore everything else about national law and deconstruct it. That's all that that's saying. And then paragraph 12, about 5 lines down, it must be stated that in order to fall within the field of social security covered by regulation 1408/71, the legislation at issue must in any event satisfy, in particular, the condition of covering one of the risks specified in Article 4.1 of the regulation. It follows that the list of risks created in that paragraph is exhaustive, and that as a result, a branch of social security not mentioned in the list does not fall within that category, even if it confers upon individuals a legally defined position entitling them to benefit. So there's 2 things being said there. One, it has to cover one of the risks, and that if it's social security, and this addresses my Lord Justice Green's question about, well, is it social security or isn't? This case is proceeding on the basis that it's social security if it's granted on the basis of a legally defined position. But it's saying, well, that's not enough. If it's doing something else other than covering one of those specific risks, it's not a social security benefit. And then at 13, as is clear from the documents before the court, the minimex is characterised...
Sorry, just before you go on, the expression a legally defined position, I mean, is that effectively an objective position which is not subject to discretion?
Yes, I look at them as limb 1 and limb 2, and coming back to paragraph 42.2 of the skeleton, there's 2 tests which need to be met. One is that it's granted without individual and discretionary assessment of personal needs.
It may be means tested, but it's not discretionary.
Exactly. So one doesn't go along and say, please give it to me, and exactly. But what the court is saying here is, well, it might do that, but that's not enough. It's got to cover one of the specific risks. And then at paragraph 13, the minimex does confer a legally defined position. So that's the first limb of the test. But and on the other, by the fact it's granted to any person who doesn't have adequate means and is unable to obtain them. It thus adopts need as an essential criterion for its application and does not make any stipulations as to periods of work, contribution or affiliation to any particular social security body. We accept that that isn't an essential, this is in older days, but the important point is at paragraph 14, an allowance like the one at issue, being a general social benefit, cannot be classified under one of the branches of social security listed in Article 4.1 and therefore does not constitute a social security benefit, and then repeated at paragraph 15, it must therefore be stated in answer to question 1 that a social benefit guaranteeing a minimum means of subsistence in a general manner, such as that provided for, does not fall within the material scope. And again, I draw the court's attention back to it has to cover one of the risks specified in Article 4.1. Now, we say universal credit doesn't cover one of the risks. It's a general global benefit like the Minimex, albeit that, as my Lord or Justice Lewison neatly put it, the amounts change depending on the person's circumstances. One of those circumstances is having children. So we say that Hux is exactly on point, and insofar as paragraph 32 of the Upper Tribunal's decision is concerned, it may not be perfectly phrased, but it's correct in the sense that if something is a general social benefit, which isn't specifically meeting one of the risks, then it's not social security. And as I've already submitted, in this respect, universal credit is not an outlier because there are other states with similar benefits.
The expression I put in my own notes in relation to Article 3, it's a ratione materiae. That's the expression they're effectively using in paragraph 15, the material scope of the regulation.
Yes. Exactly. So that's the real question, not because what is it a social security benefit could mean the narrow question of is it granted without individual and discretionary assessment, or could it be a broader question of is it within material scopes? Your Lordship is quite right. So in terms of Hughes and INPS, I've already trailed our point on these cases. The starting point is that neither of them are about severability, or alternatively put, turning something into a benefit when it isn't already. What they are cases about classification, and they're specifically addressing arguments by a state that a benefit which was specifically intended to meet family expenses shouldn't be a family benefit because it's had some additional purpose. For example, helping somebody who was poorly paid. That's all that those cases are about. They're not authority for the proposition, and it's not a proposition which is advanced, that universal credit as a whole is a social security benefit. So could I just invite the court to look very quickly at Hughes in tab 20. That's the context for this case. Just to invite the court to note, paragraph 19 begins on page 405 and goes on to the top of page 406, that what the court says is this, top line, as is clear in particular from the fact that it is paid only where the claimant's family includes one or more children. So that begins at paragraph 19. So the UK is saying, well, actually, it's got a dual function. It's not just meeting family expenses. It is encouraging workers who are poorly paid to continue working. And the court says, well, it's paid only to people who've got children. And that is one of the hallmarks of the family benefit in that case. It wasn't there a global benefit. It was a benefit only paid to people with children. So it wasn't a benefit like universal credit. And I would note in passing that this is an example of a case listening to what the member state has to say about the purpose behind the benefit, which is obviously a policy issue. And then just turning to INPS, which is at tab 35, which is another case relied on by listed down there. Again, this case, as is evident from the discussion of paragraphs 58 onwards concerned two very specific benefits: birth allowance and maternity allowance. See paragraph 58 and 61. And again, those are benefits paid only in connection with children. And what the court says at paragraph 60 is it doesn't matter that you're also trying to encourage the birth rate, that doesn't stop them from being family benefits.
I'm so sorry, which tab is that?
I'm so
It's my-
sorry,
No, no, it's my fault.
35,
Thank you.
paragraph 58 and 61, and then the passage at 59 describes the birth allowance as being intended in particular to contribute to the costs arising from the birth or adoption of a child, as its name would suggest. And then the court says and then the court uses the words in particular again at paragraph 59. It's therefore a cash benefit intended in particular to alleviate the financial burdens involved in the maintenance of a newly born child. And that's where the court then says at paragraph 60, it doesn't matter then that it's got a dual function, that you're also trying to encourage the birth rate. Now, what we say about this case again is that there's a world of difference between a specific benefit which is solely granted to families and which also happens to have another underlying purpose versus a benefit like universal credit, which is a global anti-poverty benefit. So these cases simply don't exist. They're about whether something which is specifically designed for families are family benefits. And so to wrap up before lunch, if I may, on that point.
So just to go back a little
Yes.
way, because you told us you was looking at facts. We go back to paragraph 11 of the judgment.
Yes.
And we see that Italian law introduced a childbirth allowance
Yes.
paid monthly to encourage the birth rate, etc. Then there are various other domestic provisions extending it.
Yes.
And then at 17, we see another Italian domestic provision granting a maternity allowance.
Yes.
And so what the court is considering are those two entitlements under Italian domestic law.
Yes. And they are benefits under Italian domestic law, and they've got their own names: birth allowance and the maternity allowance. And these are all cases which are specifically about family benefits.
Yeah.
Now, just to be clear, the suggestion in going through Commission and UK was that this was some kind of surprise for the UK that child tax credit was a family benefit. To be clear, the UK accepted from the outset that child tax credit was a family benefit. It accepted that in Commission and UK. There was no issue in Commission and UK about whether child tax credit was a family benefit. The court goes through the analysis, but the UK had always accepted that. It hadn't tried to say, oh, it's got a different purpose because it's helping people who haven't got much money. It accepted it from the outset. These cases are about specific family benefits. They simply don't have a bearing on this case because it's not being argued in reliance on paragraph 60, for example, of this case, that, well, universal credit is also contributing to expenses with families, so the fact it's a subsistence benefit is a dual function, because that would require the court to classify universal credit of itself as a family benefit, but it isn't, and that's not being argued. The other crucial point about all of these cases is that they have nothing to say about severance. And I think, as my Lord Justice Lewison observed yesterday in the course of argument, there's no issue in these cases about severance at all. They can't be relied on in any way, shape or form to support an argument that a court can effectively turn something that isn't a benefit into something that is. So with the exciting information that after lunch, I will move on to the case of Drea. I will stop there if that's a
That's
convenient
fine,
moment.
yes, all right. How are we doing for time? Ms. Smythe?
Good progress, I think. Yes.
Yeah, there'll be time for Mrs. Larmere to reply.
Yes, he realises some of his time has been chopped off, I think.
I had a lot of questions, but 10 minutes.
Well, I've had lots of questions as well. Yes, we both had lots of questions.
Yeah.
Yes.
As long as we finish today, that's fine.
We will do.
Right, 2 o'clock.
Court rise.
Filibuster.
What?
Filibuster.
What does that mean? What does that mean? That's a Polish word. I don't know what it means.
Filibuster means run out the clock.
Oh, shall I do that?
Speak for the sake of speaking. You're making excellent progress.